Cut. Call the first case.
Suit number HFR 211-2018 between concerned citizens of Nigeria and the Attorney General of the Federation. My lord, parties are absent.
Representation.
May it please the court, I am Stella Michael Sunday, Esquire. My humble appearance is for the claimant applicant.
Respectfully, my lord, I am M.E. Joshua Esquire, Senior State Counsel. My appearance is for the defendant respondent.
Counsel, where do we stand?
My lord, the matter is for hearing. We have an application before you and we are ready to move the application.
Joshua Esquire, have you been served?
Yes, my lord, we have been served and we have filed a counter affidavit and safe on my learned friend.
Very well. Sunday Esquire, go on.
My lord, a motion is dated 2nd May 2018 and filed on the same date. It is brought pursuant to Section 6, Subsection 6b and Section 9, Sub 1 of the Constitution of the Federal Republic of Nigeria, 1999, as amended, and under the inherent jurisdiction of this honorable court. My lord, we apprehend the court for an order of mandamus compelling the federal government of Nigeria to commence the process of restructuring the country, and any further order or others as the honorable court may deem fit to make in the circumstances of this case. Our application is supported by a 40-paragraph affidavit deposed by one Chief Nkakat, a frontline community leader and one of the concerned citizens. We rely on all the paragraphs of the affidavit. My lord, in compliance with rule of court, we also filed a written address which we adopt as an argument in support of our application. Upon receipt of the counter affidavit of the defendant, we filed and served a further affidavit and a reply on point of law. We also rely on all the paragraphs of the further affidavit and adopt a reply on point of law. My lord, I will further adumbrate.
Is that your adumbration not in this paper before me?
My lord, it is a further authority. My lord, the current system, where our state governors from all zones look mainly to monthly allocations from the center, Abuja, gives no incentive to state governments to improve their inward-looking efforts to explore locally for wealth because they do not control their resources. A restructured Nigeria, where every state will have control over its resources, will make every region of the country a wealth-creating zone. We respectfully urge the courts to grant application in the interest of justice.
Yes, counsel for defendants.
My lord, respectfully, upon being served with the application of the claimants, we filed a counter affidavit of 40 paragraphs deposed to by Christabel Edmund Esquire, a senior counsel in the office of the Honorable Attorney General. We rely on all the paragraphs of the affidavit. We have also filed a written address which we adopt as our argument in vehemently opposing the application of the claimant applicants. My lord, I will further adumbrate. My lord, Section 2, Sub 1 of the Constitution of the Federal Republic of Nigeria, 1999, as amended, provides that Nigeria is one indivisible and indissoluble sovereign state, to be known as the Federal Republic of Nigeria. Any call for restructuring is inconsistent with the clear provision of the Constitution. Furthermore, all arguments for resource control have been taken care of by the derivation principle enshrined in the Constitution. I therefore respectfully urge the Court to dismiss the application of the claimant with substantial cost. May it please the Court.
Yes, any rejoinder on points of law?
My Lord, Section 6, subsection 6b of the Constitution of the Federal Republic of Nigeria empowers the courts to adjudicate over matters between persons and the government. We submit with respect that this court has the power to grant application. Furthermore, the derivation principle enshrined in the Constitution is grossly inadequate in addressing the need for resource control. Also, my Lord, restructuring will give state control over their internal security apparatus, thus enhancing security. We therefore respectfully urge the court to grant application.
Courts. Well, I have listened to the arguments of both counsel and gone through the processes before me. I hereby adjourn this matter sine die. I rise.
Thank you very much. Thank you. We may be seated, please. Some photograph will be taken that will help these children to remember today. Please allow them, offer them the hand while we put our hands together for them. Thank you very much. As a matter of fact, counsel for the respondent is a primary one pupil.
We are Nigerians. We are one people. God made us united in our diversity. We have one history. We have one destiny. We are Nigerians. Let's rise and be